Hey, everybody, welcome back to Jersey First TV and the Nader Narrative. Always happy to bring you the intelligence of John Coyle, our resident attorney. John, welcome back to the show.
Thank you, Elizabeth. Always a pleasure.
You always help us with insight into what's going on in the Supreme Court, especially, and how that affects us here in New Jersey. And so much has been happening. There's no way that anyone out there doesn't recognize that there's been a lot of activity at the Supreme Court. Really interesting decisions, groundbreaking, historical. And we've talked about some before, but we thought it would be a good idea to come back and tell the audience about a handful of these that will ultimately potentially affect certain things in New Jersey. So, John, let's get into it. Let's start with the big one. Well, they're all big, actually, in their own context. But let's go ahead and start with abortion rights. This was leaked before, and you and I did a show where we went into great detail. We don't have to do that today, but great detail on really what the argument was and really what the historical facts were, the precedent and all of that. So June 24th, we got the official word on Dobbs versus Jackson Women's Health Organization. Tell us about the decision.
Okay, so as a plug for you to go watch the other show where we discussed it in great length, but I'll add to this. We finally saw the final decision. After the leaked decision came out and chaos ensued, we finally got the final decision. One of the things missing from the original was we didn't know who was voting on it. We didn't know the number of people. We knew it was a majority. So that implied 5 people, but we didn't know the exact breakdown until now. So the opinion is mostly identical with a few notable changes. It's about 10 pages longer, and the primary addition has been to respond to the other opinions. So there's the majority opinion, which is the official opinion of the court. Then other judges write concurrent opinions, which is where they say, I agree with the result, but I think it should have for the following reason. And then there's dissenting opinions and so forth. So the majority opinion was added to by Justice Alito to respond to all those other opinions. And that wasn't there the first time. It seems like the first opinion was sent out for everyone to then comment on, and then he took all the comments and then went back in to do this.
Right. Okay.
Now,
first of all, before you go forward, we didn't really say this is the abortion rights. I mean, everyone should know by now that Dobbs versus Jackson Women's Health Organization is going to be as famous as Roe versus Wade, really in the history books. But just in case people watching, what are you guys talking about? We're talking about abortion rights. Okay, go ahead, John.
Yeah, the biggest impact of this case, other than the obviousness of overturning Roe and Planned Parenthood versus Casey, is that this really is a paradigm shift for the court and jurisprudence. It's been many years in coming, but this is the official, if you were to call this the coming out party for the Thomas Court. I think you could actually call it that. We've referred to this court as the Roberts Court, typically referring to this by the Chief Justice. And for a long time, when the court was 5-4, with Roberts in the middle as the Chief Justice, a conservative justice, at least on paper, you would have 4 on the more liberal side and 4 on the conservative side. And wherever Roberts came down, that was the majority. As a matter of fact, there's some statistic that Roberts was in the majority something like 98% of the time. His 5th vote was the vote, whichever side he picked, right. Whether it was Obergefell about legalizing gay marriage, he was the 5th. On the decision to uphold Obamacare, he was the 5th. It was the Roberts Court. Then the makeup of the court changed, and we have 5 more conservative justices, the 3 liberal justices, and Roberts. And now Roberts is not necessarily part of the majority. And this is the coming out, for really lack of anything else, of the Thomas Court. And I'll tell you what I mean by this. Roe versus Wade, we all know what Roe versus Wade is, but Roe versus Wade is the court looking at the issue of abortion and saying, the court actually said, I can't tell you what right in the Constitution this is affected by. Right. The opinion said, I think it's the 14th. That's what we believe. But it's not. We're not saying it's the 14th, but that's what we prefer, the 14th. But it could be any other list of other amendments. We think it's there somewhere. And regardless of where you feel on abortion, it's always been a very badly reasoned constitutional decision. The purpose of the Supreme Court is not to make law. The purpose of the Supreme Court in our federal system. We have states, we have federal government, we have legislature, state, and federal. The purpose of the Supreme Court is to decide federal constitutionality. It is clear that there's nothing in the Constitution about the right to abortion or even the right to privacy that they sort of found by looking at a bunch of amendments and saying it's probably in some of these. Okay? But Roe was the court saying up until the first trimester, the state doesn't have the interest in regulating what happens to the woman's body. Then comes Planned Parenthood versus Casey 2 decades later. And people talk about Planned Parenthood versus Casey as just an extension of Roe, but it wasn't. In Planned Parenthood, you had 4 judges who said we should throw out Roe. Okay? You had 3 judges who said Roe's great. And then you had 2 judges who said Roe's wrong, but we still want to uphold abortion. And the way something works like that, where you have this whole split opinions, there's no 5-person majority opinion. So what you do is you look to see what's the common ground for 5, and that's the plurality opinion. So that becomes the new holding of the case. And what happened in Planned Parenthood is 3 who said Roe's okay, and 2 said we should replace Roe with a viability standard. We're now going to make viability the test. And viability became the standard because that's the least common denominator of 5. Okay, so Roe's gone. People talk about overturning Roe. Roe hasn't been good law since the 90s.
Very good point.
Okay. This case, Dobbs said, we need to look back at this entire thing in the first place. And they said, viability doesn't make sense. We could talk for 2 hours about the nuts and bolts about the Dobbs versus Jackson. If we'd like to have a follow-up on this, we can. We got a lot to cover today.
Right.
So I'll try to do as little as we can. But the point is, the court said viability doesn't make sense. Viability has never made sense because viability is something that changes over time. Is it 35 weeks, which is what it was in the 1800s and the 14th Amendment was passed? Was it maybe 40 weeks in colonial era? And as the court even notes here, it changes depending upon where you are. If you were in a urban place in the United States with access to high-level medical care, viability might be different for you than if you're in a rural hospital.
Right.
How could it be constitutionally permissible to change people's rights depending upon where they live? And what the reason this is a paradigm shift for law, and it's not about to go away, is that the court said, let's go back to the Constitution. And if it's not here, we can't touch it.
Right.
I'm sorry that this has been the law of the land for 50 years. And as we talked about at your prior case, the Supreme Court has constantly overruled decisions in the past. Everyone on TV is talking about stare decisis and these judges lied and everything else. This is a straw man argument. The court has always gone back and fixed things that are wrong. Otherwise, we'd be stuck with the Dred Scott decision, which said enslaved people who got to free states were their master's property and sent them back.
Yeah.
Right?
Yeah.
That's not the law anymore. Brown versus Board of Education, separate but equal is not equal, overturned Plessy v. Ferguson, right? Those were pretty big shifts too. I'm not trying to minimize the impact on people, but the Supreme Court said, we are not outlawing abortion. We are, or we're also not endorsing abortion.
Right.
We are simply saying this is for the states.
Right. And that's the bottom line, John. And it's throwing the football back to the states. It's a constitutional decision. They're saying basically that we got it wrong. They weren't the same body, but the body of the Supreme Court got it wrong. This does not belong as a national issue, as a constitutionally protected right. So therefore, as are most issues, that goes back to the states. Now, that is the key. There's a lot of misinformation about this, and understandably so, because it is an extremely delicate issue, right? A lot of emotions. You see the reactions from both sides to the morality of it, but that's not what was in front of the Supreme Court. You'll see people posting life won. Well, that's not actually true. Once again, because it's a constitutional issue, you'll see people saying, women no longer have rights. That's not true. Again, back to the states. So now let's talk about the states. Each state is different. New Jersey recently passed a very aggressive abortion rights law, probably one of the most aggressive in the world, whereby you can have an abortion up to the point of delivery and sometimes right after. I don't totally understand that, but also anyone from anywhere in the world that wants to come here will have that paid for. So that's in contrast to another state, maybe South Carolina, that doesn't allow for it. So John, talk about why it's so important for people to understand this is a state issue. And if you're upset, you can do something about it in your state.
That's right. And I'd like the news to say when they have a demonstration and violent protest in California or New Jersey and New York about this, they should tap people on the shoulder and say, it's legal here up to the moment of birth. You really need to find somewhere else to protest.
Yeah.
Right. There are lots of things that are state issues. And I tried to think about it over the weekend and come up with an analogy to this. Right. In New Jersey, the age of consent for sexual relations is 16. Okay. It's not 16 in every state. It's 17 in some states. It's 18 in other states. And in New Jersey, it could even be under 16 if you're not more than a certain number of years older. And it's over 16 if the person's in a position of authority. This is a complicated thing. We're not here to legislate the sexual laws here. The point is, this is a very detailed, crafted, nuanced legislation that has gone through the works. And what it is in New Jersey is not what it is in another state. Right. What is rape in New Jersey is not rape in another state, and vice versa. Right? This is as fundamental an issue as we're talking about. New Jersey has its own laws, and these other states have their own laws. And if another state wants to say an abortion after 15 weeks, when there's a fetal heartbeat, or when there's fetus feels pain, or at any point, that is up to that state to make that decision. Much like many other things in our life.
Much like many other things. And well, I really think what's happening here is, once again, we as citizens need to look in the mirror and say, what are we doing in our, at a state level? Are you voting? Are you getting behind candidates? Whatever your opinion is on this, and you feel as though you're not represented, what are you doing about it? I would go so far as to say that what won, if you want to say, was the Constitution. And it's interesting because that's really ultimately what we would hope the Supreme Court would be doing. When you read some of the dissenting opinions, maybe it doesn't feel exactly like that, but ultimately, again, it was a matter of constitutional law. So that's, and I want to go back. We're going to go through a few more of these agreements, but our decisions. It's interesting, the split of 6-3 on a lot of these.
Cheat sheet.
Yeah, you got your sheet there. It's interesting that the split, what it is, somewhat potentially disheartening, even though, some of these cases came out, I would say, in favor of people who believe in the founding documents as they were, but kind of curious why it's always the same people. So let's move from abortion rights. Again, everyone's state issue. Now you need to focus on your states. Let's go to the June 23rd decision on the Second Amendment. And this was New York State Rifle and Pistol Association versus Bruin. What was that decision, and how does it affect us in New Jersey?
Can I stall and say one last thing on the Dobbs case before we talk about the NRA, because
do.
It's an important end piece. I apologize, I'll be
Sure.
brief. This was a 5-justice opinion with 1 concurrence. We talked about Chief Justice Roberts not being there. Justice Roberts, his concurrence was not to overturn Roe and Casey, but to instead look at whether the state's law gives the pregnant woman, and I won't say pregnant person, enough notice that they were pregnant. Okay? We almost got a new standard replacing Casey that said, has there been enough time for the pregnant woman to notice she was pregnant?
Wow.
We came this close to this.
That's fascinating. That would have been a whole different standard.
What is this? And he would have said, I'm okay with Mississippi's law because 15 weeks is enough for somebody to have noticed that they were pregnant. And when we talk about this no longer being the Roberts court, that's what this means. Justice Roberts would make up his own opinions. He was comfortable saying, I'm going to make up a notice standard. That's nowhere in the Constitution.
Nowhere.
And the Thomas Court said, let's read this thing. And if it's not here, it's not in our opinion. And this is going to be a major shift. And it goes right into the NRA case we're talking about, right? And the NRA case was an extremely interesting one. It's the Bruin case, the NRA versus Bruin. Everyone knows about the Second Amendment. And I'll preface this by saying the following. For decades, anybody talks about the Second Amendment, they say well-regulated militia being essential to the free exercise this country, the right to bear arms shall not be infringed. Right. And everyone's been said that 100 times. But that's not what it says. It says the right to keep and bear arms shall not be infringed. Everybody that skips the word keep end when they repeat it, and the Supreme Court said those words have meaning. This is 19 words. Keep end are 2 of them. And the court said, let's look at what was meant at the time of the Second Amendment, to keep and bear. And they looked at that at the time of the Bill of Rights. They looked at it at the time of the 14th Amendment, incorporating it into the states. And they said keep and bear mean 2 different things. And it says our founders were 100% clear that the right to keep and bear arms for self-defense was a balancing act. There's obviously a balancing act. And any type of right, there's a right on both sides. The idea of the state regulating your ability to lawfully bear arms for self-defense is something that was essential to the framers and essential at the time of the 14th Amendment in the post-Civil War era. And they said, we have to read those words to mean what they meant at that time, back to the Thomas Court. We're not making up a new reading. We're saying, what was it say at the time it was written? And keep and bear mean 2 different things. And bear is a right. And this gets back to New Jersey. At issue in the case was a specific phrase called proper cause. Okay, there's a standard for getting a carry permit in New York. It included that you were licensed, that you had all these other things, and that you had proper cause for it. And the court noted that there's 6 states with the same proper cause requirement, including New Jersey. And the court said proper cause, as has been interpreted by the court, is in violation of the Constitution. You don't have to show proper cause that you have a right to do this, right? Because in practice, anyone who's applied for a carry permit in New Jersey knows New Jersey's interpretation of proper cause is you're not getting one.
Right.
And that was the same in New York. And the proper cause standard has been written out of the law. And within days of the decision, the New Jersey acting attorney general issued a directive order that said from now, as of immediately right now, the standard for a carry permit in New Jersey, still need a permit. I had people call me, can I carry my gun? You can't carry your gun.
No, right.
No, you can't carry your gun.
Right.
You can apply for a permit. And all those other requirements, except for proper cause, are there. You need to show you're proficient in it. You got to go out to your range, go to RTSP and learn how to use a carry permit. You're going to need to do a background check. You're going to need to be licensed, and you're going to need to apply for it. The only thing you don't have to show is proper cause anymore.
So that's a huge change. So once again, we have the Supreme Court deciding strictly on constitutional language, which is fascinating. Keep and bear, 2 very different things. If you're keeping a gun in your safe, that's much different than bearing one on your person. So that's interesting. And again, affecting other states. So New Jersey is really needing to change that. Otherwise, they're obviously going to have a lawsuit pretty quickly based on that decision. So once again, not to simplify this, but the Constitution wins in its original form, strictly interpreted in this case. It's Absolutely. A fascinating case. It affects so many people. And we'll have to see now what happens with the numbers in New Jersey with the carry permits, because in the past they've been so strict and so few. So that's very interesting as it relates to those of us in New Jersey. Okay, so again, we'll come back to the split because I'm going to ask you at the end about that a little bit, but it also split 6-3, same individuals, I believe, as the split for the abortion decision.
Absolutely, 6-3, the same 6, except Roberts was in the majority this time.
Okay.
And in the dissent, we're talking Sotomayor, Kagan, and Breyer. They're the, quote, liberal wing of the court.
Right.
And the common theme on almost all these cases we're talking about is they dissented uniformly on all of them, no matter what the topic is.
Yeah, isn't that interesting? And I think my concern there is, if we see a court changed, a packed court, or, in the future, again, are they really making decisions based on the Constitution, or is it based on a worldview, right? And that's concerning. So, all right, let's move to June 27th. Here's a school prayer decision, Kennedy versus Bremerton School District. This one is exciting, just came out. Tell us about it.
Yeah, so this is a tremendously interesting case. This is one that a lot of people closely monitored, and it really has to do with two related questions that people tend to lump together. Right? You've got the Establishment Clause from the First Amendment, what they call the part of it saying the Congress shall pass no law to establish a religion, the Establishment Clause, and they have the free exercise, nor infringe on the free exercise of religion. They're calling those the establishment, which is the government shouldn't endorse a particular religion, or free exercise, which is they shouldn't interfere with your free exercise. And there's a related issue of that, which is the free speech part of the First Amendment. There's really three religious components in the First Amendment. And the free speech part comes into play in that you could talk about your religious beliefs, and that's a free speech and a free exercise issue. But you could have a free exercise issue that doesn't involve speech. But so over the course of time, these issues of establishment and free exercise get blurred. And there's no better case. So if you want to see these get blurred by people who don't know what they're doing, it's this case, okay? The Kennedy Bremerton case. And the reason I say this is because for those people who don't know this, this is a coach, a deeply religious high school football coach who after games would kneel to thank God for the health of the players and everything else. He was a Christian man, and he would do it at the center of the field every day. And this went on for years, and nobody said anything about it until an opposing coach called to thank the superintendent, saying it was inspiring to see this. And he goes, wait, what? And then they shut it down. And they told him, you can't kneel after a game because that violates the Establishment Clause. People are going to think that this is government-sponsored religious activity. We are establishing it by you kneeling after a game. And he said, no, this is interfering with my free exercise of religion, right? And it push and pull back and forth. These obviously are similar in nature, but the Establishment Clause really turns on whether something is a government action and whether people would believe that this is endorsing something by the government, right? A coach kneeling after a game is not establishment violation. Somebody getting on the loudspeaker to recite a prayer as part of the morning announcement it's an official government action that would be reasonably perceived as being endorsed by the school. And this case, when they told the coach, you can't do this, he said, okay, I'll wait till the players leave the field and get on their buses, and then I'll pray. And the school said, you can't do that. And then he said, what if I just nod my head and I don't do anything demonstrable? And they said, you can't do that either. Wow. And then he argued that after the game, all the coaches and teachers and everybody there, they do exercise some supervision over the parents, over the students, but there's free time. People call loved ones, people make dinner reservations, people take pictures, people do all those other things. And he says, well, they're doing all those things. Those aren't government sponsored. No one's thinking that these restaurants are doors. I just want to pray.
Right.
And he doesn't make a big deal out of it now. And and then he was fired. And he was fired because they said, you're failing by taking that time to pray, you're failing to supervise the students in your charge.
So they just blew this up into a big thing.
They did. Yeah. And it's because they couldn't get past the idea that if, and by the way, not just the school, but the district court and the circuit court came out and said, anytime he's doing this, it is establishment of religion. It's violating the Establishment Clause. And Supreme Court said that's not what it ever means.
Now, I'm sorry, I just wanted to ask you quickly, the Lemon test, yes. This is what essentially struck this down. I was reading about it. They call it the dreaded Lemon test. Why is it dreaded?
Well, it's dreaded because you get into the idea of what's being established and what's being endorsed, and whether it's the kind of action that you're taking, that how is it going to be read and perceived by people at the times. It's sort of going into this. Sometimes we can regulate speech that is religious when depending upon where and when you say it and the time in which you say it. And it creates such a mushy area. And the Supreme Court said, if you buy the lower court's decisions on this, that a coach praying after a game is of establishment, then that means that a teacher at lunch who says a quiet prayer to himself before eating lunch is violating the Establishment Clause.
Yeah.
or a Muslim woman who wears a hijab during school is violating the Establishment Clause because she's performing her jobs.
Right.
And the court really said, you need to look at this. And if you are outside of your official government responsibilities and how you're acting, you are on your own. And it is outside of the Establishment Clause, doesn't touch this. And there's obviously overlap. He's after the game. He's going to pick the kids to the bus. But they said this is not official government action.
One of the quotes from the decision said, "Respect for religious expressions is indispensable to life in a free and diverse republic. Whether those expressions take place in a sanctuary or on a field, and whether they manifest through the spoken word or a bowed head." That's a tremendous sentence. And once again, religious freedom protected. Incredible decision. As you said, many people watching it, and again, split 6-3. Really
same
along
6-3 split.
Along what we could go ahead and call partisan lines, frankly. I think it's safe to say. Another issue, June 21st, another decision that is with a religious bent to it, of course, separation of church and state. This has to do with Maine, the state of Maine, and it was Carson versus Maine, and it was about religious schools being excluded from state tuition program. Talk to us about that decision, because it, again, relates to another religious freedom issue.
Right. It's, again, the split of the misunderstanding of what the establishment versus the free exercise clause do. I used to live in Maine. Maine is rural in a way you can't conceive of anywhere in New Jersey. It's got 1.1 million people in an area like twice as big as New Jersey. It is so spread out and far flung. And about half the areas in Maine, there is not a high school. There's not a local. It just doesn't support it. It's too far flung. Right. So in half of those places, in all those districts, the state says you can take the check we would send for your education and use it to go to school anywhere, in a different state, in a different country, in a private school, except in the early 80s, they changed it to be like, but not religious school, not a religious school. Okay. And they said, because that would violate the Establishment Clause by sending a check from the state to a parent who gives it to a religious school, you're establishing that school as religious for the purposes of the government. And it's really hard to say that with a straight face and have that be taken seriously. And the court is the Supreme Court. Again, that same 6-3 split, we're going to keep saying it, was unkind to the fact that the courts below completely ignored the precedent on this. Yeah. You have a neutral policy. You are giving parents the ability to pick where they want to send their kid to school, to a private, to a public, to a different town, or to a religious school, as long as it met certain criteria. And those criteria had to do with the education, had to do with what it's qualified for, and all those other things. And if you met those criteria, you could use that. That sending that check was not establishing the religion. And if you're not establishing the religion, now you get to a question of, is it an undue burden on the religion? Now the state has to prove that this is the least restrictive way that they could have enforced this. And they can't do this, right? This is, again, establishment and free exercise. That is not this. Now, this case doesn't have some of the broader discussions people have talked about in terms of endorsing vouchers on a national level or anything else like that.
No. Sadly, no.
It's really in the area of Maine where there are not schools for half the people in the state.
Right. It's not a decision on school vouchers. Obviously, that's not what was in front of them. And therefore, how does it affect us in New Jersey at the moment? It does not. However, it could potentially. And, were we ever to get true school choice, were we ever to get anything like that in any state that doesn't have it today, this decision obviously would guide, I'm sure, future decisions in those states as to your ability to take those funds and use them wherever you want to for your children. So sadly, in New Jersey, guys, doesn't help us right now, but it's good to know that the precedence exists. Another great decision, another constitutional win. Two more for you, just smaller ones. I don't want to say anything is small coming out of the Supreme Court by any means,
No.
but maybe didn't get as much attention and happened earlier. But I think when you look at all these decisions together over the past few months, it's a pretty fascinating profile of what's coming out of the Supreme Court. On May 2nd, a decision in Shurtleff versus Boston. I don't know if I'm pronouncing that right, but this is First Amendment in public forums. Court ruling the city of Boston violated the First Amendment and refused a private group to raise a Christian flag in front of its city hall. Any comment on that? Again, freedom of religious expression.
Yeah, it's the exact same story as we just saw before. This is a common theme. That's why these cases are important, even though they're lesser in the sense of overturning Roe versus Wade and reshaping the Second Amendment, but still important, right? It's the same question. The city of Boston raises a flag, and they allow 20 times a year groups can post things, pride flags, civic flags, all sorts of other flags. There's 20 times a year that they don't weigh in. They just give you a date and you can do what you want. They don't raise it for you. You get to hang it for a day. You get to take your pictures, do whatever you want, and you lower it. And then the question came, somebody said, I'd like to do a Christian flag. And they said, that's establishing religion. That's violating the Establishment Clause. And the court said, no, it's not, for the same reason. And there's a different cases, and sometimes we talk about these things as cut and dry, but really there's a lot of nuances on both sides. There's a case over time history where they said a monument on government property is establishing it. If you have a religious themed monument that somebody private pays for, but you put it in front of the town hall, that's considered establishing. That is a monument for those purposes. But somebody running a flag that you don't edit, don't choose, you just have people apply for a permit, you get to fly a flag, then that's not establishing it. And in response to this, the city of Boston canceled this.
Of course.
They canceled this program because the perception. That's right. And there's other Supreme Court cases that said, like, a license plate is establishment. You can't sponsor a license plate to be like Jesus Saves and have that be part of your license plate. That's considered establishing it.
Right.
You can't have a group through the, all the million license plates that you have.
Right.
But a license plate would believe to be people to be establishing that as endorsed by the government. But a flag as one of the random 20 days is not. Well,
that was a 9-0 decision.
That's correct. And that's the one exception to everything we're going to talk about today, is that, like, despite all these other things, that even the dissent, and it was complicated, lots of different opinions, but the bottom line is, like, that doesn't violate it. Now,
bottom line, right.
But it feels like beginning of May was a long time ago, and it is. It's long before this leak of the Supreme Court and people are showing up to try to kill judges who are going to vote a certain way. And I wonder if that would be 9-0 if it came in front of the court today.
Oh my gosh, such an interesting point, and a little sobering to think about. One more that was even before that, which again seems smaller, but nothing is small coming out of this institution. March 24th, so long before all of this, religion and the death penalty. This was a case, of course, in Texas. Ramirez versus Collier, about a death row inmate and his ability and his right to have his pastor come in, touch him, pray aloud prior to his execution. Anything in this case that, again, defending religious freedom, right?
Yeah, it's both narrow and a forecaster of all the cases that we've talked about, right? It's covered under, and I had to write this down so I get this right. It's under a specific law called the Religious Land Use and Institutionalized Persons Act, okay? And that act applies to set rules for prisoners in these types of situations. And one of them is that the prison cannot impose rules that would unduly burden the free exercise of his religion. But it comes to, everything is a balancing test. It's not that you can't do it, but now you need to show that there's an interest for it and a compelling need for you to do this in the prison. In this case, the prison said, we recognize that telling him his pastor can't come in and lay hands on him is violating his religious exercise. But it's for an important reason, which is that the pastor could use this opportunity to grandstand and make a giant show about it and do something to disrupt the execution. And the court said, there's no indication that this is what's going to happen. This is a man who is about to be executed for a horrible crime.
Yeah.
And he just wants to go into the afterlife in his chosen way. And this is how this goes forward. So while it's a small case in those words, it's not, because every time we clean up what free exercise of religion means and strengthen it, whether it's a prisoner or a flag or a student or any of these things, you are making a step forward towards, and I believe, the country that our founders created, which is a country of people who had religious beliefs, and those were supported. They weren't forced on anybody else or encouraged over anyone else. But the religious history of our country is indispensable.
Well, that's one of the themes of this season of the Supreme Court, for sure, is reestablishing those rights as given to us in our Constitution, and frankly, for those that believe, given to us from our divine. But on that decision, there was a dissenter, which is Thomas. So explain that to me. It was 8-1.
Well, Thomas's dissent was that this is not the standard that we should be applying to this decision. Thomas's dissent was, in fact, a forerunner or precursor to his decision since then, which is that, like, we shouldn't have a separate body of case law for RLIAPA exercise of religion and the actual exercise of religion under the First Amendment. So Thomas dissented, but not for the reasons that he thought this person should not be allowed to have their religious freedoms for it. It was, in fact, a textual argument for it. And if I have 4 minutes left, Elizabeth, I'd like to make one last thing to circle. I'm going to do this. Sorry, to circle back to the Dobbs, because this is something I want everybody to leave here and think about. Okay, because this is the most important of this. It's not. We all know that cases get overturned and the Supreme Court changes its mind. The dissent in the Dobbs case said it was okay for the court to revisit Plessy versus Ferguson, separate but equal is allowed, to go to Brown versus Board of Education, because there'd been 60 years and the civil rights movement had passed through the course of time, and there'd been a consciousness changing, and now it's okay to go back and revisit this. And they wouldn't say that Plessy was wrong. It's that it's now wrong, the distinction being the two of those. And the majority said, this is absurd. Cases get decided wrong, and wrong is wrong. Plessy was wrong. Plessy didn't become wrong because we had 60 years of segregation and 60 years of Jim Crow. That didn't make Plessy wrong. Plessy was wrong. And it doesn't matter if it's a day or 60 years. We need to go back and correct it when, over the course of time, the court gets it wrong. And it's the central biggest philosophical or theoretically legal question about Dobbs, and something that Justice Kavanaugh raised at oral argument on this case, which is, we all know that Plessy was wrong, but was it wrong before the court issued Board of Education? Right? Did it just become wrong because we reversed it, or was it wrong? And if it was wrong a year before, if it wasn't wrong a year before, we should have never heard the new case.
Right.
We heard the new case because we were open to the argument that the first one was wrong.
Right.
And it doesn't matter if it's 60 years or 3 years. Plessy was wrong. And the court here is saying, you have to do this here. And we know this is going to be disruptive. But it is not for the court to make up lines and pick 15 first trimester, second trimester, 20 weeks, 15 weeks, 18 weeks. That's not for us to do.
No.
We decide this thing, the Constitution, and that doesn't have that stuff. And that's for your legislature. And they even say, it even says women play a role in politics that was not the case even at the time of Roe. They said in the 2020 election, more women voted for president than men. And women are in elected positions in Congress and in the state houses in greater numbers. And they say, what side you are on this, you should go run for office, support candidates who you like, or get involved on a grassroots level and vote. And that's how this is decided in a democracy. And that's how we are. We don't live in an autocracy where 9 people in robes get to say what the laws are for people.
Yeah.
And they said we recognize it's chaos, and all the articles that say it's overturned, all that stuff. It's simply saying it's in the 98% of all laws that are for the states, and that's the think about this. And
98%.
right,
Words
maybe I
matter.
got that wrong.
No, but it's an overwhelming majority of the laws that were intended to be made by the states. That's what makes the United States so fascinating and diverse and different, and frankly gives you power as a citizen to impact things that you normally wouldn't be able to impact. Now, I think that's a genius way to kind of close on the Dobbs thing, so people hopefully can really understand this. Of course, as we speak, we have the passage of a gun control bill very quickly in DC. We have other states, I'm sure, that will be making moves in the abortion arena. We have Pelosi threatening to try to pass a bill and really trying to use this to affect the midterm so that Congress can try to establish a law. So the point is, John, we have a lot more to talk about in the near future because it's not over yet. But this has been the most fascinating discussion. I'm sure people who are legal eagles will love to hear all of this. We always appreciate you sharing it with us. What an interesting year in the Supreme Court. And I just want to say yay for the Constitution. That's what I want to say. That's the celebration I think we should all have.
I agree. And I would tell anybody that you're probably well served to not read any news coverage of any of these things, regardless of what the source.
These
are long opinions. That's
yes.
right. These are long opinions. But to give you a hint, on the Supreme Court website, you can read all of these for free with a mouse click. And they give you the Cliff Notes version. The clerk's office gives a syllabus where they take the 200-page opinion and they distill it into 4 pages, and they tell you what it really means. Read it.
Absolutely. Read it and understand it yourself, or listen to this interview.
Listen to this interview. That's right. Or tune into the Nader narrative. You'll get this up-to-date information anytime you can.
We'll always have it here. John, I can never thank you enough for your insight. You're so talented. We appreciate you. Maybe someday we'll see you up on that bench, huh? You're a young guy. You never know. There could be DC in your future, right? John, thank you.
Maybe not in DC, but we'll see.
We'll see. All right, John, thank you so much. And to my audience, guys,